Okay, so here we go. The next part. We're going to revisit Penoyer. Assume Mitchell sues Neff in Oregon, alleging that Neff hired Mitchell to perform legal services in Oregon and failed to pay Mitchell the resulting legal fees. This sounds like a breach of contract. Also assume that the suit arose after intentional shoe was decided and that Mitchell found Neff in California and served Neff with process in California. Would it be constitutional for the Oregon court to exercise in-person jurisdiction over Neff? So Mitchell sues Neff in Oregon, alleging that Neff hired Mitchell on legal service in Oregon and failed to pay Mitchell the resulting legal fees. Also assumed that the suit arose after international shoe was decided and that Mitchell filed in California and served Neff the process in California. Yes, because Neff had contact with Oregon and the claim arose out of that contact fee. A is incorrect. Serving Neff in California does not by itself establish a basis for personal jurisdiction in Oregon. Neff was personally different. That's true. Yes, because Neff had contact with Oregon and the claim arose out of contact. That's the correct one. C, no, because Neff was not served in Oregon's borders. He doesn't have to be here. Minimum contact in Oregon to which the suit was arose. And no, because Oregon is unrelated to Neff's contact with California. So C is wrong as well. After international shoe, a defendant may be sued in the state, even if she is not personally served in the state where the court sits, as long as the claim arose out of her minimum contact with the state. B is also wrong. Although the Oregon claim is unrelated to Neff's contact in California, that's not the issue. The issue is whether Mitchell's claim arose out of Neff's contact with Oregon, the state which Mitchell filed the suit. The answer is B. Neff hired Mitchell in Oregon, and Neff failed to pay Mitchell in Oregon. Mitchell sued Neff for the failure to pay fees in Oregon. Neff therefore had contact with an Oregon, and Mitchell's claim arose out of that contact. Thus, if the suit were brought today, Oregon court could exercise in-person jurisdiction over Neff. In addition to highlighting how personal jurisdiction doctrine has evolved, this question also illustrates how much clearer the distinction between personal jurisdiction and notice has become. Penoyer, the two concepts were integrally linked. Personal service in the foreign state sufficed to establish jurisdiction. After international shoe, however, personal jurisdiction now typically turns on whether the defendant has sufficient contacts with the foreign state and not on where the defendant was notified or served. The issue of whether the defendant is properly notified of the suit is now a separate question subject to different rules and different constitutional analysis. We'll study that in chapter 10. Trying on the shoe, with international shoe. Would it be constitutional for a court to exercise in-person jurisdiction in the following case? If so, what type of in-person jurisdiction, specific or general? A. Demo, the Pennsylvania company from the earlier note, sends one of its products by mail to Paula, a California citizen. The product interests Paula in California, and she sues Demo in California. There will be no specific jurisdiction over Demo in California. Demo made a deliberate contact with California in sending the package to the state. The claim arises out of voluntary contact with the state. B, same as A, except that Paula sues Demo in Pennsylvania. There will be general jurisdiction over Demo in Pennsylvania because Demo is the home state for the company. C, same as A, except after her injury, Paula moves to Arizona and sees Demo there. Assume that Demo's only contact with Arizona is that it recently sent a catalog to potential customers in the state. That would not be in personal jurisdiction in the state. There's no general jurisdiction because Demo does not appear to have sufficient contacts for Arizona to be considered at home there. Rather, from what we could tell, Demo merely sent one catalog to the state. That doesn't meet the minimum contacts for specific jurisdiction. There is no specific jurisdiction. Although Demo does have contact with Arizona, it's a catalog there. The claim does not arise out of that contact. Rather, the claim arises out of Demo's contact with California. As a result, there is no personal jurisdiction in Arizona for the case. D, same as C, except the lawsuit is brought by the Arizona citizen as a result of fraudulent claims in the catalog sent to her in the state. I think that's breach of contract too, but even though Demo's contact with Arizona are exactly the same as they were in C, it would have personal jurisdiction specific in this case. The key difference is the claim arises out of Demo's contact with Arizona, whereas C, the claim did not. Specific or general jurisdiction in international shoe. 8. Based on the context of that international shoe had with the state of Washington, what type of personal jurisdiction could have been exercised by a Washington court over international SHU? Surely there will be specific jurisdiction. International SHU had contacts with Washington, the representatives that sold the company SHU there. Moreover, the lawsuit around unemployment compensation payments that were owed because of the employment of those sales representatives. The court wrote the obligation, which is here sued upon, arose out of international SHU's very activities in this forum. The court also noticed that international SHU's activity in Washington were neither irregular nor casual. They were systematic and continuous throughout the years in question. However, these activities were probably not sufficient to support general jurisdiction. A corporation can have an ongoing contact with the state, but not enough context to support general jurisdiction. See Daimler AG v. Ballman, 2014, make the distinctions between having continuous and systematic context and being at home in the firm. Thus, international SHU's limited but ongoing sales in Washington were probably not sufficient to support general jurisdiction in Washington. Giving the boot to Pennoyer. Page 174. In some respects, international SHU overrules Pennoyer. After international SHU, a court can exercise personal jurisdiction over a defendant, even if that defendant was not served within the state, was not domiciled or present in the state, and did not otherwise consent to being sued in the state. Contexts provide a new and independent basis for establishing personal jurisdiction that did not exist under the Pennoyer framework. At the same time, some basic principles of Pennoyer remain intact. The territorial authority of a court is still important. For example, a defendant must generally have a contact within the forum state in order to be subject to a lawsuit there. Moreover, some of the basic methods of establishing personal jurisdiction remain effective. For instance, personal service on an individual defendant while the defendant is within the state still supports personal jurisdiction, at least in some circumstances. Burnham v. Superior Court 495 U.S. 604, 1990. Domicile and consent also remain legitimate basis for establishing personal jurisdiction. Finally, the focus on the company's presence and whether it is doing business in the state has morphed into a conceptuality similar doctrine, general jurisdiction. So although international SHU expanded the permissible scope of a court's personal jurisdiction authority, some of the underlying principles of the doctrine contained in Pennoyer remain good law. So let's see here. Challenging personal jurisdiction, part 1. Special appearances and alternatives. Historically, defendants have used two different procedures for challenging personal jurisdiction in court where the lawsuit was filed. Traditionally, defendant could challenge personal jurisdiction using a special appearance. More recently, several alternatives to special appearance have emerged. Special appearance. The court notes that international SHU appear especially in Washington to contest personal jurisdiction. At that time, most jurisdictions held that defendants waive any objection to personal jurisdiction if they appeared in court and raised any issue other than personal jurisdiction. If international SHU had not made a special appearance for the sole purpose of raising personal jurisdiction, a company would have waived the issue and could not have raised it later. Okay, yeah. So if you come to court and you waive any other issues besides personal jurisdiction, at that time in most jurisdictions, the defendant, they waive their objection. So you can only come here and say, hey, you don't have jurisdiction over it. That's what it was at that time. Alternative to special appearance. The federal courts in a growing number of states have jettisoned the technicalities of special appearance requirement. Instead, they allow a defendant to object to personal jurisdiction by filing a motion to dismiss or obtaining or objecting to jurisdiction in answer to the complaint. But even in jurisdictions that have eliminated special appearance for defendants must generally raise personal jurisdiction early in the case in order to preserve the issue. Challenging personal jurisdiction, part two. So that was part one, special hearing, part two. Okay, direct challenges versus collateral attack. Direct challenges in the court where the lawsuit was filed are not the only way to contest personal jurisdiction. A defendant may also raise personal jurisdiction in a collateral proceeding. To employ a collateral challenge, the defendant must fail to appear in court where the plaintiff filed the original lawsuit. This failure to appear eventually results in a default judgment against the defendant. The plaintiff can take that judgment to the state where the defendant resides or has assets and ask the court in the state to enforce the judgment under the full faith and credit clause. Although courts typically enforce judgment from other states' courts under the clause, that objection only exists when the original court entered a valid judgment. In a collateral challenge, the defendant appears in the enforcing court and contends the original rendering court judgment was invalid for lack of personal jurisdiction and should not be enforced. So basically, you're trying to sue me. I don't go to court. I say you don't have personal jurisdiction because I don't show up. You automatically get the judgment. Then you have to come to my state and you have to go to court and say, hey, I want you to enforce this judgment. Even though states enforce the judgments of other states, they have to be valid. So at that hearing where you're trying to get your money or whatever it is you want me to do, I say, hey, that's not valid because they didn't have personal jurisdiction in the first place. Lawyering strategy, direct or collateral attack. Under what circumstances would you advise a client to challenge personal jurisdiction collaterally? This tactic is very risky. By not appearing in the court that entered the default judgment, the defendant has waived any opportunity to contest the plaintiff's claim on its merits. Thus, the defendant's collateral fails. If the defendant's collateral challenge fails, the enforcing court can order the defendant's assets to be sold to satisfy the default judgment. Given this risk, a collateral challenge only makes sense if the defendant has no defense or a very weak defense to the plaintiff's claim on merits. The amount at issue is so small relative to the amount of money it will cost to mount a defense, and the argument against personal jurisdiction is particularly strong. Under these circumstances, it might make sense for the defendant to default in the original court and let the plaintiff try to enforce the judgment wherever the defendant has assets. If personal jurisdiction in the original court is questionable and the amount at stake is small, the plaintiff might not bother to go to another state to enforce the judgment. In that case, the defendant will have saved the expense of showing up in a distant form and face a limited risk of having to pay a significant judgment. So you really only want to use this if you don't have a defense. You're like, I really don't have a defense on merit. The only defense that I have is that this court doesn't have personal jurisdiction in the first place to use it in. Or it's just that the amount of controversy is so small, it's going to cost me more to travel to the forum state in the first place. So I might as well let them get the judgment. And then even if I lose, I still have less money. 13, easy way. Recall from earlier chapters that a party can typically raise subject matter jurisdiction for the first time long after the case has begun, even on direct appeal. Why is personal jurisdiction, unlike subject matter jurisdiction, so easily waived? Subject matter jurisdiction concerns the court's constitutional authority to hear a case. Without the power, the court's decision can have no legal effect, so the parties have no authority to waive subject matter jurisdiction. In contrast, personal jurisdiction is not a limitation of the court's inherent authority. It is a procedure of protection for a party, typically the defendant under the 14th Amendment due process clause. If a defendant wants to litigate in a state that the plaintiff has chosen, the defendant may waive the procedural safeguard of personal jurisdiction. In other words, personal jurisdiction is the defendant that is personal to the defendant, where subject matter jurisdiction implicates systematic concerns. So, personal jurisdiction is personal to the defendant. Subject matter jurisdiction implicates the systematic or the court's concerns. So, therefore, you can waive personal jurisdiction. You can say, I'll hear the case here if you want to. that's fine. But the court has to have the right by the system, so it just can't be waived. Appealing adverse ruling on personal jurisdiction in federal courts, and in some states, the defendant cannot immediately appeal a trial court's finding that has personal jurisdiction. In these states, the defendant must wait until the trial court enters the final judgment in the case, which could take years. There's an obvious problem with the quote. The parties might litigate the entire case only to have the appellate court rule that the trial court did not have personal jurisdiction in the first place. The entire case would then have to be relitigated in the form that's personal jurisdiction, resulting in an enormous waste of time and money. To avoid this problem, some states allow the defendant to immediately appeal a trial court's ruling on personal jurisdiction. This process of appealing an issue in the middle of the case is called interlocutory appeal. Although interlocutory appeal um, although interlocutory appeal solve some problems, they create others. For example, they have the effect of dragging out litigation because the trial court proceedings may be put on hold until the interlocutory appeal is resolved. Big shoes and long arms, the role of long arm statutes. International shoe considers the constitutional scope of personal jurisdiction, the outer limits on the court's authority to assert jurisdiction over an out-of-state defendant. However, the Constitution does not automatically confer personal jurisdiction on the courts of a state. The state legislature does. Each state specifies how expansively its court can exercise personal jurisdiction. As long as that specification is within constitutional bounds, states typically define the reach of personal jurisdiction in their courts through statutes, often called long-arm statutes, which specify contexts with the state that allow the courts to assert jurisdiction over the defendant. Some states may authorize personal jurisdiction through other statutes, such as business registration statutes, director constant laws, and non-resident motorist statutes, as in HEX. Thus, the court can exercise personal jurisdiction only if it has constitutional authority to do so, and the relevant statute, usually long-arm statute, authorizes it. So it has to be constitutional. It has to have a constitutional authority and the relevant statute. Constitutional due process under the law, and then is the big circle, and then inside of it is statutory authority under the long-arm statute. We saw a similar relationship between statutes and constitutional authority in the subject matter jurisdiction context. Recall that Congress can pass or has passed statutes that give the federal courts less than the full scope of constitutionally permissible subject matter jurisdiction. Congress, however, cannot confer more subject matter jurisdiction than the Constitution permits. As the diagram above demonstrates, long-arm statutes work the same way. A court typically does not have personal jurisdiction unless it is both granted in the long-arm statute, the inner circle, and permitted under the Constitution, the outer circle. A court does not have personal jurisdiction unless it both is granted the long-arm statute, the inner circle, and permitted under the Constitution, the outer circle. A case must fall within the bounds of the court to have authority. Must fall. You can't just be in one or the other. Because many states' long-arm statutes simply give the courts as much personal jurisdiction authority as the Constitution allows, the outer circle and inner circle are the same in those states. Because many states' long-arm statutes simply give courts as much personal jurisdiction authority as the Constitution allows, the outer circle and inner circle are the same in those states. Chapter 9 examines those situations where the long-arm statute offers less than full scope of constitutional authority and is thus a smaller circle than the constitutional circle, as in the above diagram. That chapter also describes how the issue is handled in federal courts. In the meantime, Chapter 7 and 8 offer more detail on the size of the outer circle, so the size of the constitutional authority under the Due Process Clause.